In 2019, the state brought a case against a founder of defunct Capital Bank Ato Essien and two others over their alleged involvement in the collapse of the bank. The state then had also accused Mr. Ato Essien of misappropriating 620 million Ghana cedis of liquidity support from the Bank of Ghana to help keep the bank, or Capital Bank then, afloat. Well, it was advertised after 3 years of trial that on November 30, 2022, judgment will be pronounced. However, the first accused, Mr. Ato Essien, entered into an agreement with the state coming to the court on Section 35 of the Courts Act. The agreement was that the first accused, Mr. Ato Essien, would pay back 90 million cedis to the state. The court was skeptical about this, with the presiding judge, Justice Chebafo, noting that really the monies involved in this matter belong to depositors and shareholders. And so judgment on that day was not pronounced. But finally, judgment has been pronounced. The court has rescinded its earlier decision on the restitution deal, the 90 million cedis restitution deal. And so today, the second and third accused have been acquitted, with Mr. Ato Essien, the first accused, to pay back, or ordered to pay back these monies to the state. Let's bring you the reactions of the second and third accused after they walked out of the courthouse free men. The third accused person leaving the court premises now. So we'll see if we can engage him briefly for a discussion on how he feels, so he can tell us at least just a few words. Exactly.
The Lord has done it. The Lord has done it.
How are you feeling now, sir?
The Lord has done it. The Lord has done it.
It's been a long 3 years. A long 3 years for you. What's the feeling like for you, sir?
The Lord has done it. The Lord has done it.
We see expressions of joy on your face. Really tell us what your sentiments are.
We just thank God for everything. It's just by His mercies and His grace. We give Him all the glory. He has sustained us during this time. And I give thanks to Him and also to all those who have supported me during this time. The glory goes to the Lord. Thank you very much.
On all that has transpired in court and how you're feeling now.
Well, I'm grateful to everybody who supported us. Grateful to everybody. Thank you very much.
Did you come to the court with this conviction that today you're walking out a free man?
I wasn't sure what would have happened. I mean, it's been 5 years, so it's okay. It's okay. I'm grateful to God, and thank you to you all. Thank you.
All right. Thank you very much, sir. Alfred Tua Yeboah is a deputy Attorney General, and he engaged the media after proceedings. All right. Thank you very much, sir. Reactions after proceedings today.
That's the beauty of litigation. You come to court, you may win, you may lose, you may win parts and lose parts. At the end of the day, the state has won part of this matter. The second and the third accused person have also been acquitted and discharged. They've also won the other side of the matter. You see, in terms of prosecuting financial crimes, you have two main approaches. You prosecute and as much as possible also recover. So if in the course of prosecuting the matter, an accused person comes out with an offer that's reasonable to the state, we'll consider it and look at the way forward. Because an accused person may be imprisoned, the money that if prosecuted on may still be with him, he comes back and enjoys the booty. Because at the time that you were investigating, you couldn't have any inclination as to where those monies had been hidden. So if possibly, in the other cases, they make offers and we deem them to be reasonable to the state, we may consider it. But if there are offers that are unreasonable, we will not accept them. We'll go ahead and do our work as prosecutors. Last time that we came, there was no opportunity for the parties to explain how they came by the 90 million Ghana cedis. In fact, the first accused person, Ato Essien, has always insisted that he has an amount not more than 57.5 million Ghana that he thinks he has stolen. 57.5. And we also were of the view that even if he accepts the 57.5, the money has been with him for some time. So we insisted on getting some reparation for the state. So out of the 90 million, over 32.5 forms part or is part of the reparation. So 57.5 as the admitted sum. The state is being compensated by way of reparation in the sum of 32.5 million Ghana cedis. So this is business for the state. To the state, it's reasonable.
Honorable, we're happy with this settlement plan, but I also want to believe there may be a plan in the event of a default.
Certainly, it's so clear in our terms of settlement. If the first accused person decides to pay 19.99 million Ghana cedis by the 28th of February, the following day, we'll make sure that he's arrested and brought to court the following Monday. So we expect him to go by the terms of this agreement. We will not, under any circumstance, even extend it by a day. We are monitoring, we keep our diaries, check the accounts of the Bank of Ghana to see whether those monies have been paid. If he pays them, so be it. If he doesn't, then the courts will definitely deal with him.
The court makes an interesting observation of P13, the CEO of Nordial Company Limited. Did this open your eyes to something you may have not averred your mind to?
Yes, when it comes to prosecution, we choose our witnesses. We are not compelled by people to choose our witnesses. The court has made some findings. We will study the findings and see how we can also take a step on it if need be. But in terms of we choosing our witnesses, nobody chooses our witness for us. There are even instances where an accused person is even used as an accomplice witness. It's possible that two people may commit a crime, we choose to charge one and use the other against the other accused person. And in this world of plea bargain, you are going to see most of these things where we may even want to bargain with an accused person, get a conviction, then use him against other accused persons allowed under our laws. So
Right.
the judgment.
The argument today was upheld that the monies involved are state monies. But what do you say to depositors and shareholders who may have been following this case?
The depositors and the shareholders, the government has taken it as a policy to pay the depositors of the defunct banks. And this one is also a wake-up call to the other financial institutions that the state will not rest until just brought to the depositors and the people of Ghana. Because the state will not spend over 25 billion and allow people to use the money with their families and then they will enjoy out of it. We are ready and willing to pursue every city that the state has used in paying back the depositors.
My colleague Hansen Achiman has been following this matter keenly. He sat through proceedings and listened to that judgment, and he's joining me now to give us more details about this. Hansen, we heard of an advertised date for judgment. Let's begin the journey from there. Why was that judgment not pronounced on that day? And then tell us what has happened afterwards.
Well, so the judgment was supposed to be given on November 30. However, on November 29, when the judge had finished writing his judgment, he was notified of this agreement under Section 35 of the Courts Act, which in essence makes an accused person to plead guilty to a charge of causing financial loss to the state, and instead of a custodial sentence, the said person will be made to either pay compensation, restitution, or reparation to the state. But the judge at the point felt that the instant case did not fall under the ambit of offenses that cause financial loss to the state, and also the fact that the amount of money that was supposed to be repatriated or paid back to the state in the eyes of the judge was not commensurate enough with the amount of money allegedly stolen at that time. So he gave them time to go and ponder over these two stands of his objection to the plea, and then come back and address the court. So essentially, what they came to do today was to address the court on the applicability of Section 35 of the Courts Act, and also justifying the terms of the agreement between the first accused person, Ato Essien, and the state.
What happened thereof. Judge may have come to the court with a written judgment, but then, of course, now that this plea or this agreement had been established, what changed?
The judge was of the considered view that regardless of this plea of guilty and this restitution deal, because there are two other accused persons involved, he should read his judgment as prepared. And this judgment may touch on counts against the first accused person, but the focus essentially is to give the fate of these other two accused persons. The lawyers of the first accused person was of the view that the judge, by reading this, would undermine the very essence of the Section 35 which they've come under. And so it was their view that the judge shouldn't read a judgment at all. The judge then adjourned for a brief moment to consider whether or not to read the judgment in its entirety or to segregate and take out portions relating to Ato Essien. He came back and took out portions relating to Ato Essien. So he read his judgment against, or his judgment in relation to Tetenete, who is the director of the MC Management Services, who was charged primarily with conspiracy counts of stealing, of money laundering, and also abetment counts against Fitzgerald Odonko, former managing CEO or manager of the defunct Capital Bank, whose accounts were mainly abetment to commit crime, that stealing and money laundering. At the end of the judgment being read by the court, the totality is that these two accused persons have been acquitted and discharged. And the court found out that the prosecution did not give enough evidence to indicate that these two persons, in essence, actually conspired or either abetted with Ato Essien to commit this particular crime. So they have been acquitted and discharged on all counts of stealing and money laundering that they were facing. But interesting to note is that during the judgment of the court, the judge noted that there were instances where that one of the witnesses of the accused, PW13, he was a CEO of Nordia Capital Limited. Now, this is the company that transferred 65 million Ghana cedis that was made to him by Capital Bank Limited into the account of the MC Management Services. And this was made without any form of trace of paper documentation. And the court noted that that witness, in essence, should have been a matter of interest to prosecution and even been under investigation or being charged for conspiracy himself.